Good afternoon, jury members. Uh, Respected jury members, we are waiting for our two other jury members to join the session. Then we will commence the final moot court round. We are just waiting for two jury members to join the session. Good afternoon, dear jury.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, respected jury. Today we have finally reached to the final round of fifth online national moot court competition. I, Parth Trivedi from Anand Law College with Mr. Ranveer Singh Mahida and our court assistant Utsav Shah from BBLLB student welcome respected judges and participants in the final round of fifth national online moot court competition organized by Anand Law College and Anand College of Legal Studies. It is my honor that I welcome and introduce our today's final rounds judges, Ms. Tuti Kapadia ma'am, President of Juvenile Justice Board. Welcome ma'am. Mr. Harshad Rai Dave sir, welcome sir. Mr. Hardik Dave sir, we welcome you sir. Mr. G.Y. Pathan sir, we welcome you sir. Mr. Jappan Dave sir, we welcome you sir. Mr. Rahul Dave sir, we welcome you sir. And Mr. Pawan Barot sir. Once again, we welcome all the jury members of our today's final event. Before starting of the event, I am just reading out our today's final round instruction. In the final round, the win or loss shall be decided Based on the aggregate score, no memorial score will be added in the finals. Each team will be allotted a total of 40 minutes to present their oral arguments. The timing can be divided between both the speakers according to the wishes of the team, subject to maximum of 25 minutes and minimum of 15 minutes per speaker. The time division has to be informed to the court manager, clerk, assistant before the beginning of the oral arguments. A maximum of 5 minutes may be reserved for rebuttal or sir rebuttal round, which shall be given at the discretion of the judges, which shall be exclusive of the above time limits in both semi-final and final rounds. Respected jury members, Team 1 and Team 6 have qualified for final round. Team 6 is representing from the petitioner side and Team 1 is representing from the respondent sides. After your prior permission, we can commence this session. With your prior permission, sir.
Yes.
Yes, you may proceed.
Okay. Team 6, you may proceed.
Greetings to the bench. The council seeks permission to refer to the bench as your lordship.
Yes,
Much
you are.
obliged, your lordship. If it may please this honourable court, this is the council appearing on the behalf of petitioners in the case of Hare Paryavaran Ke Nirman versus State of Indica, along with Vinupal University versus State of Jalka, along with Mr. Wet Maddox versus State of Indica. If your lordship is well versed with the facts and jurisdiction of the case, the council would like to proceed to the issues at hand.
Yes.
Much obliged, your lordship. We have 5 major issues in the instant matter. Issue number 1, whether the petition is maintainable under Article 32 of the Indian Constitution. Issue number 2, whether the government is liable to compensate the residents due to the injury caused to them due to gaseous emissions from industries. Issue number 3, whether the students who were peacefully protesting can claim compensation for the physical injuries and mental trauma suffered due to protest. Issue number 4, whether the university can claim compensation for the rapid decline in admission of foreign students due to degrading air quality and scarcity of water in Delta. Issue number 5, whether Mr. Wright Maddox and Mr. Maddox Vance can claim the right to stay in Indica for completing their further education. The present council shall be dealing with issue number 1 and 2. Subsequently, the next council would be coming to deal with issue number 3, 4 and 5. The council seeks permission to move to the arguments advanced and issue number 1. Much obliged, your lordship.
You may
The
proceed.
Much obliged, sir. Issue number 1 is whether the petition filed under Article 32 is maintainable or not. It is humbly submitted before this honourable court that the instant petition is maintainable since there is violation of fundamental rights, that is Article 14, 19 and 21 of the Indian Constitution, owing to the arbitrary actions of the state. Further, there is no requirement for the petitioners to exhaust alternate remedies. In any case, the alternate remedies available are not efficacious enough. This honourable court has a constitutional obligation to hear this case under Article 32 of the Indian Constitution. Further, this honourable court has rejected arguments in the past that call for the exhaustion of local remedies on many occasions, as stated in the case of Khadak Singh versus State of UP. Further, this self-imposed restriction to not entertain certain writ petitions which have not followed the usual path of coming to the High Court and then the Supreme Court is only a matter of convenience and discretion, and it does not preclude the court's jurisdiction under Article 32. Further, the Article 226, wherein High Court has the jurisdiction to hear the present matter. Article 32's remedy is a basic right, not merely discretionary function of the court, and that's the reason we have approached the Supreme Court over High Court. Further, the National Green Tribunal, which was set up under NGT Act 2010, is able to hear the matter only in the cases of environmental degradation and not in the other 2 petitions which we have filed, that is in the case of university and Mr. Wright Maddox. Further, we submit that the agitating the proceedings in 2 different courts, if in case it was available to do so, it would be a very cumbersome process for the petitioners. Thus, it is submitted
Madam,
that
just a minute. Just a minute. You just now raised a contention that the alternative remedy is not efficacious. Can you point out how it is not efficacious?
And
Indeed, Your Lordship.
first tell me what is the alternative remedy available to you?
There
Which
are two.
alternative?
There are two alternative remedies available here: High Court under Article 226, and also National Green Tribunal, which could be seeken by us in the first writ petition, that is her NGO versus the state of Indica. But since the three petitions have been clubbed together and they are so intermingled that they couldn't be adjudged separately, thus instead of going to National Green Tribunal, the Supreme Court also has the ability to hear the instant case. Further, if we talk about High Court and under Article 226, the High Court's powers are merely discretionary, but Article 32 provides us a basic right to approach the Supreme Court under Article 32. And that's the reason the petitioners have
And for other petitions, you have alternative remedy to approach the civil court for compensation. You can go there.
Your Lordship, I've already stated that the matters are so interconnected that approaching different courts in the same senses would be very cumbersome process for the petitioners, and it will be very time consuming to the already increasing burden in the law of courts nowadays, and that's the reason the petitioners have approached this honorable court. And
How it is interconnected?
Okay. Your Lordship, the increasing pollution is the problem in the instant matter, due to which the NGO has filed the writ petition against the government for not combating the pollution. There were few students of prestigious university, that is Vinupal University, who decided to peacefully protest for the same, but that protest turned into a very violent one, which led to a very uh, which led to loss of public and private property. Thus, the university and the NGO's petitions are intermingled. Further, Mr. Red Maddox, who is a student of Vinupal University, was found to be involved in passively participating in inciting the protesters and making it turn violent. And further, he has also a connection with the environmental pollution, where he got the lung cancer because of the increasing pollution levels. And when his brother, Mr. Saus, decided to donate his lung to him, he died in the process of operation due to the micropollutants present in the air. So these technicalities make it very difficult for these three cases to get separated, and that's the reason.
That is true. That is true. Let us believe that this cannot be segregated. It is possible for us to relegate all three cases to the High Court. What is your submission?
Your Lordship, in the High Court, it is merely a discretionary function of the court, but Supreme Court, as it gives us the basic right under Article 32 for remedies, for the constitutional remedies, if any of our fundamental rights get infringed, and thus, if we
But
thus
226 is more wider.
Indeed, Your Lordship, the powers under the Article 226 are wider, but in the instant case, we perceive that Supreme Court is more capable to hear this petition, since
Then High Court should, the all High Court should be shut down. Only
no,
Supreme Court. That's all.
no, that's not the case, Your Lordship. Since the matter is so wide and in general interest of a very large section of the society, that's the reason we have approached the Supreme Court in the present case. The Council seeks permission to move ahead to the issue number 2.
Can you please read the reliefs you have sought for? Prayers.
Pardon?
Prayers. Prayers.
Can you please read the reliefs?
The prayers, right?
Yes, prayers.
Yeah.
What relief you have sought for?
Okay. So in the it is prayed in the light of the case, issues raised, arguments advanced, that in the issue number 1, we seek for compensation from the government of the Indica for all the residents who were affected by the gases emissions from the industries. We also seek a compensation for the students who were peacefully protesting and were injured when the protests turned violent. Also, in the second petition, which was filed by Vinupal University, we seek compensation for the university owing to the decreasing number of admissions because of the rising pollution levels. And in the third petition, wherein Mr. Wade Maddox filed the petition where he was ordered to be deported, we want that petition.
All three are different cause of actions, madam. All three seek different prayers,
Indeed, Your Lordship.
right?
Indeed.
Therefore, in first, where the trust has come forward seeking compensation, there is an alternative remedy to go to NGT or to High Court under 226. So far as the university is concerned, university is seeking compensation, again disputed question of facts are involved, you go to civil court, is altogether a different thing than connected with the pollution. And the third is cancellation of visa. So again, a different cause of action. So we don't find it to be intermingled with each other. All are severable. Everything you can go and deal with before the separate forum.
Your Lordship, the increasing pollution levels have undeniably effects upon the cases of Vinupal University versus State of Delhi, along with Mr. Wade Maddox. They are in certain senses connected because of the pollution where the protests happened and then they turned violent, and then Mr. Wade Maddox was ordered to be deported because he was involved in those protests which were related to environment pollution at the very first place, and then his getting a lung contacting lung cancer because of the environmental pollution in the same matter. That's the reason we have filed the petition.
You just tell me one thing. You have said that you have filed this petition before the Supreme Court on the ground that it will be more suitable for to implement the fundamental rights. That is true. You can do it, no difficulty. But at the same time, if you will go before the NGT for pollution, they have their own mechanism to understand all these technicalities. And against the order of NGT, you can move before the Supreme Court if need arises. If you go for a compensation before a civil court, then you will get all chances for appeal and everything. And thereafter, you can come to the Supreme Court. If you will move to the High Court, then also in SLP you can come before the Supreme Court. You are losing your right of an appeal. What do you want to say?
Your Lordship, though we could refer to High Court and National Green Tribunal and civil courts in three different cases, like separately. However, in the instant petition, we sought to seek remedy from this honorable court, since the interest vested in are very wide. There are the interests of the general public, which is a very wide in journal, and then also we could appeal further in a Supreme Court once we after we did it in the High Court. But it would be very time consuming for us and also cumbersome.
And if everybody starts thinking like you, Supreme Court will be flooded with
What
matters.
is the litigation?
Then same problem would arise here also.
Your Lordship, the co-counsel would like to comment about this.
Yes.
Like,
Yes.
Your Lordship, according to the current circumstances, the situation demands urgency. If we approach High Court or the NGT, we can again they can again appeal in the Supreme Court. So ultimately, it comes to Supreme Court, and we do not want to waste our time by appealing in High Court or.
Every litigant wants speedy justice.
Pardon, Your Lordship.
Every litigant wants speedy justice. There is no litigant who wants that I will get my justice within number of years, then it's okay. Everybody wants speedy justice. Why
Your
special
Lordship,
treatment to you? Why special treatment to you?
That's because our case is not only it would affect the whole society. People are dying, they are getting cancer. It depends. It is for the greater good of the people that we're approaching to the Supreme Court.
It
For
is
the
only in
welfare
the
of-
state. It is only in the state of Delhi, right?
No,
So
you
there
have
is a pollution problem is with the state of Delhi. That-
Your Lordship, including even in Indica, there's a problem of increasing pollution, not only in the state of Delhi.
Today you are here with the case with respect to Delhi only.
Yes, indeed, Your
Right.
Lordship.
Then better you go before the High Court. High Court has ample powers to look for this for its jurisdiction and wider power than the Supreme Court under 32. Right?
Taking
Your
in
Lordship, yeah.
Your Lordship, taking in account some precedents, it has been mentioned that when there are extraordinary circumstances, the petitioners can directly approach Supreme Court under Article 32. And in this situation, as per the NG report, there are many people dying. 3096 people died of the pollution, and 2091 people got severe illnesses. Though the number is small, looking at the extent of pollution, but in itself it is very large. Every life matters, and also it is having severe impact on the environment and also the fundamental right of other people. And that's why, looking at the extraordinary circumstances and urgency of the situation, we have seek to we have come here in this honorable court for the petition.
What about the third petition, Mr. Maddox's petition? Right? What fundamental right of yours is violated?
uh, in the uh, in the third petition, Article 21, uh, where Article 14, I get. Just give me a minute.
Your Lordship, in the third petition, the Vienna Convention and the principles of natural justice itself says that both the sides should be heard, which is one of the most important principles of natural justice, which says "Audi altem partem," and the government deported those two individuals without having a fair trial. Therefore, the right to fair trial is their right, which is being violated. Additionally, in Article 36 of the Vienna Convention, it also assures that the detained foreigner shall be provided with all the resources they require to mount up a strong defense. Therefore, we are approaching the Supreme Court in the third petition.
You have a right to appeal there. You can
Right to
approach. You have a right to appeal. Your visa is cancelled. You can approach the Ministry of Foreign Affairs by way of an
the,
appeal.
uh, your lordship, as told by as being said by my fellow counsel before, that these three matters are somewhere interlinked. That is why we have clubbed, the Supreme Court has clubbed the three petitions and are hearing the three petitions together. So there must be some interlink between the three petitions that the Supreme Court decided to club these three.
Maybe so, but today we are raising this query. You respond to this query.
Uh, your lordship, the council feels that the matter is intertwined with, somewhere it is related to the environmental pollution, somewhere not. Ultimately, it is related to environmental pollution. Because of all that, this situation has arisen. That is why we are approaching the Supreme Court in all the three petitions, seeing the urgency. Their right to education would be violated if they're reported. They won't be able to pursue their studies further in the university if they are deported.
Very
Therefore,
well. Very well. You can proceed.
Now the council seeks permission to move to the issue number 2.
Yes, you may proceed.
Much obliged, Your Lordship. The issue number 2 is whether the state is liable for compensating the residents of Indica for the injuries caused to gaseous emissions from industries. It is humbly contended before the Honorable Supreme Court of Indica that the state is liable to compensate the residents since there has been violation of fundamental rights, and also there is failure of state in order to take strict measures against the increasing levels of pollution. Article 14 of the Constitution forbids arbitrariness and guarantees right to equality before the law and equal protection of the law. There must be positive requirement of reasonableness and fair play in all the actions of the state. Further, principles of natural justice are also considered to be a part of Article 14. The court held that natural justice is an integral part of equality under Article 14 because violation of a rule of natural justice results in arbitrariness, which is the same as discrimination. Here, in the instant case, the state didn't take any strict measures in order to combat pollution. Even if taken in form of some statutes, they have been in the form of paper only, and they have not been enforced effectively. Also, the state's noble act of distributing 2 masks per family is not very reasonable, since 2 masks per family are not that much, and they can't do anything when people are dying of the pollution. Further, it is contended that there is violation of Article 19 in the instant petition. Article 19 subclause 1G of the Constitution gives citizens a fundamental right to practice any profession or carry any occupation, trade, or business. However, this right is restricted under Article 19 subclause 6 in the interest of general public. Even the Calcutta High Court has ruled that Article 19 subclause 1G does not guarantee the fundamental right to carry on a trade or business which generates pollution. No one has a fundamental right to manufacture, sell, and deal in any industry which produces sound beyond the permissible limits or which generates pollution which would endanger health and public order. In the case at hand, it can be observed that industries are liable for making the environment toxic for all the residents. The groundwater table is depleting. The water is being overexploited. Drinking water has become contaminated. Um, Thus, it would be reasonable to put restrictions on the industries liable. By putting restrictions, the overall quality of the environment will most likely be improved, and consequently, achieving the goal of providing citizens with a healthy and clean environment will be met. Further, further there has been some employment opportunities generated, and there has been development in economic development in the countries. But the risk of potential harm to the environment and human health resulting from the development should be considered by somewhat tilting the balance towards preserving the ecology and environment in the interest of larger public. Thus, it is humbly contended that state has failed to take the note of Article 19 of the Constitution, and industries can no longer work in the negligent way they were doing from so long. Further, it is contended that there is violation of Article 21 as well in the instant matter. The enjoyment of life and its attainment, which includes right to life with human dignity, includes environmental conservation and preservation, ecological balance, free of pollution of air and water, and sanitation, all of which is necessary for life to be maintained. In Subhash Kumar versus State of Bihar and others, the Honorable Supreme Court held that the right to live is a fundamental right under Article 21, and it includes the right of enjoyment of pollution, free water, and air for all, full enjoyment of life, and if anyone endangers or impairs that quality of life in derogation of laws, a citizen has right to have a recourse to under Article 32 of the Indian Constitution. Further, Article 25, Clause 2 of the United Declaration of Human Rights ensures right to standard of adequate living for health and well-being of an individual. From the facts itself, it can be clearly concluded that the environment is being harmed and the well-being of the citizens is in danger. Various health concerns have arisen and numerous people have died. Thus, it is humbly submitted that the government has failed to provide a healthy and safe environment, thus violating the right to life and liberty of the people in there. Also, the government has failed to comply with the directive principles of state policy. The Constitution of India, in terms of Article 48A, mandates that state is under constitutional obligation to protect and improve the environment. And this responsibility is also clearly stated in the United Nations Conference on the Human Environment, that is Stockholm Convention 1972, to which India is a party. Furthermore, according to the parents patria principle, the state has a duty to the people to ensure protection of environment and to act where there is reasonable apprehension, suspicious, or proof of adverse effect on the environment. Further, Article 51A of the Constitution, inter alia, requires citizens to protect and improve the natural environment, but the government cannot shed off its responsibility owing to the above article. Further, it is submitted that there is the violation of public trust doctrine here. The public trust doctrine states that the state is the trustee of all the natural resources which are by nature meant for public use and enjoyment. The state as a trustee is under a legal duty to protect natural resources. The doctrine was followed wherein it was observed that deep underground water belongs to the state in the sense that the doctrine of public trust extends thereto. The state has duty to protect groundwater against excessive exploitation. Also, in Sayyid Ratnabhai Sayyid, the court referred to the Latin maxim, Salus Populi Suprema Lex, which connotes that health, safety, and welfare of the people is the supreme law. Also, where in the areas where there is a difference between the public and collective goods against the private rights, the former has to be given the weightage and the latter has to take a back seat. Thus, it is submitted that in violation of the public trust doctrine, as well as there is applicability of the principle of the polluter pays principle in the present case, which is being defined in the Indian Council for Enviro-Legal Action versus Union of India case, that declared that redemption of damaged environment is a part of the process of sustainable development. Considering the widespread ramification of hazardous or inherently dangerous activities, persons or the institution would be liable, absolutely liable, though they have even though they have taken reasonable care for the same. Thus, the compensation would be twofold: one, to compensate the victims for pollution, and also for restoring the environmental degradation. Therefore, in the instant case, industries are too liable for their acts because of the violation of the aforementioned principle. Thus, owing to the above contentions, that is, there has been violation of fundamental rights, that is Article 14, 19, and 21 of the Constitution, and even the state failed to fulfill its obligation of providing a healthy environment to its citizens. Also, the state didn't comply with the directive principles of state policy. The and also the international conventions it is answerable to. The state further failed to comply with the doctrine of public necessity, and also there is applicability of polluter pays principle here. Thus, the industries are to be held liable in the instant case. So, if uh, your lordship is satisfied with the above arguments, I would like to invite my co-counsel to the virtual podium to address.
Just one query, one query. You are invoking Article 19(1)(g), right?
Right.
Would a PIL be maintainable for invoking Article 19(1)(g), right to profession? Who has curbed your right to profession or any other purpose?
Your Lordship, in the case that the industries have the right to profess in any way they possible, but there are some restrictions onto that too. They should not harm the environment in any way possible, and thus industries being liable for exceeding the pollution limits are infringing upon the fundamental rights of the citizens.
Correct, madam. The 19(1)(g) is invoked by you for whom? Which petitioner?
The which petitioner, as in?
There are 3 petitions you have filed, right? One is by the trust, another is by university, and the third one is
Petitioner number 1.
petition number 1.
As they have filed a petition on the behalf of citizens of the Delika.
Right, but is there any restriction put by government that you are not supposed to profess any profession? Is there any restriction?
Yes.
Who is restricted? Which citizen is restricted? If there is no restriction imposed by anybody, Article 19(1)(g), how can you invoke 19(1)(g)?
There is restriction under Article 19, I guess, subclause 6.
What restriction is
In the
imposed?
interest of the general public, there is the restriction.
But there is no restriction you are canvassing that this is the restriction whereby your right is violated. Pollution is by somebody who is not a party before us, and you want a relief from somebody else. Your profession, nobody has stopped you from professing your profession. So the question of 19(1)(g) in PIL, I don't think that it would be helping you.
Your Lordship, the Council is contending that the state has violated Article 91 subclause by not putting adequate restrictions on the industries. The right under 91, 19 right to trade and profession, that has been violated of the citizens because the state did not put adequate restrictions on the industries.
Are
Therefore,
industries before us?
pardon, Your Lordship?
Are industries before us? So you want state to initiate some action against the
Against the industries.
Are industries before us? Without hearing them, how can we, on one hand, in one petition you are contending that without hearing somebody, the orders are passed cancelling their visa. Today you want Supreme Court to pass some orders against industrialists or industries without hearing them.
Your Lord,
So, in the Your Lordship, in the Moot proposition itself, it has been mentioned that owing to the increasing industries, there has been increase in pollution levels in the region of Delika too. And on those bases, we are contending that there should be some, at least an expert committee would be taken care of whether the industries are liable. But since it has been mentioned in the Moot proposition, in the fact itself, that industries are liable for the same, and these are the grounds for our contention.
Very well.
One more thing. You have two prayers. One is with regard to that compensation of the university, and the second is that the person wants to come to Indica for completing his studies. Both these things cannot be taken care of by online education.
No, Your Lordship. Since there is a lot of difference in the online and offline education, as we are seeing nowadays, the online education is not that effective as offline it is. Thus, they should have the choice whether they want it to be online and offline, and we can't put a restriction on them that you have to take the classes online only, and we are not providing any offline classes.
Great.
Okay.
Yes.
You may proceed, Airport.
Greetings to the bench. The present council would be dealing with issue number 3, 4, and 5. The council now moves to the third issue. The third issue at hand is whether the students who were peacefully protesting can claim compensation for the physical injuries and mental trauma suffered by them due to riots. The council contends that right to peaceful protest and assembly is a fundamental right under Article 19. It is also a very well settled principle that a mere innocent person in an assembly cannot be accused of as a member of that unlawful assembly. In the garb of taking action against protest march, which later turned violent, the state authorities cannot penalize innocent protesters by not giving them adequate compensation, as the violent activities were dominated by a few miscreants who consequently hindered the right to free speech and expression of other innocent protesters. As concerned citizens, the students participated in the peaceful protest, but because of it, they ended up being the victims, who were subjected to physical injuries due to riots and mob violence accompanied by mental trauma. Along with that, some miscreants assaulted and groped female protesters who were peacefully protesting, violating their right to dignity and right to peaceful protest. Sexual violence is not only an unlawful invasion of their right to privacy and sanctity of a woman, but also a serious blow to her honor. It leaves a traumatic and humiliating impression on her conscience, offending her self esteem and dignity. Secondly, it was because of the government's failure to restrict the rising pollution level, students had to step out and put their lives at risk. The protesters only wanted to peacefully convey their displeasure regarding the rising level of pollution in the state of Delhi. Thirdly, according to Section 18A of the Human Rights Protection Act, where inquiry discloses the commission of violation of human rights or negligence in the prevention of violation of human rights, it may recommend to the concerned government or authority to make compensation or damages as the commission may recommend. So here, the students can claim compensation because they sustained injuries, both physical and mental, because the government was not able to restrict the rise in pollution levels. Therefore, the council humbly submits that the victims must be compensated for all the trouble they have endured because of current state of affairs and incapacity of the government to keep a check on the industries. The council now seeks permission to move to the fourth issue. Uh, the fourth issue at hand is whether the university can claim compensation for the rapid decline in admission of foreign nationals due to rise in pollution levels in the state of Delhi. At the outset, the council contends that government is liable to compensate Venupal University for the losses it may or may have suffered due to continuous degradation of the environment. Right to compensation forms an integral part of Article 21, which further puts an obligation on the government to protect and improve the quality of the environment. It is also the duty of the state to ensure ample number of quality educational institutes exist as per fourth sustainable development goal. Moreover, the government must provide a favorable environment where the students can go without any risks or fear. Educational institutes play a vital role in deciding a country's global position. However, by looking at the current scenario in Delika, wherein majority of the students come from foreign nations, the number of students enrolling is rapidly decreasing owing to the risk of health hazards caused due to increase in air and water pollution. This will have an adverse impact on not only the infrastructure but also the economy and foreign student ratio. In MC Mehta versus Kamal Nath, Supreme Court observed that pollution is a civil wrong against the community as a whole, which amounts to infringement of Article 21 of the Constitution, and hence the court has the power under Article 32 to award compensation to the victims of pollution. The sole reason of losses being suffered by the university is because of the dangerous level of emissions from the industries. The principle of strict liability is invoked here because even though the government is not directly liable, it still plays its part in students not coming to the school because it was not able to control the pollution level in the city. Therefore, the council submits that government must be ordered to compensate the university. The Council now seeks to move to the fifth issue. The fifth issue at hand is whether Mr. White Maddox and Mr. Maddox Wen can claim their right to stay in Indica for completing their education. Firstly, the Council humbly contends that neither Mr. White Maddox nor did Mr. Maddox Wen had the intention to incite violence and cause riots. Criminal law stands on the maxim actus non facit reum nisi mensit rea, which means there can be no crime without an evil mind. The Supreme Court in the state of Maharashtra versus Ahmed Jor upheld that criminal intent is a psychological truth that must be proven in every criminal case. Mr. White Maddox used Snapchat with a bona fide intention of helping others and becoming aware and standing up against the injustice meted to them by the government so that no one else has to bear the same fate as his brother. Secondly, it is contended that there is always a chance for reformation and rehabilitation. Mr. White Maddox, at the time of commission of the act, was suffering from significant emotional disturbance and was agitated at his brother's tragic death. Therefore, we cannot call him as a chronic offender, as he only participated in the protest to make the citizens aware. Thirdly, one of the most important principles of natural justice, as mentioned before, is audi alterum partem, which means to hear both the sides. Article 36 of the Vienna Convention also assures that the detained foreigners shall be given all the resources they need to mount a strong defense and are treated equally before the law as the domestic residents. However, Mr. White Maddox and Mr. Maddox Wen were both deprived of a fair trial. They shall at least be given a chance to prove their innocence. Such haste and arbitrary decision by the state are against a natural justice policy. Therefore, the Council humbly submits that the court shall order the government to reconsider its decision and give the petitioners an opportunity to prove their innocence. If your Lordship is satisfied with the arguments and has no further questions, the Council would like to move to the prayer.
Madam, you might be aware of the Citizenship Amendment Act, right?
Indeed.
There is a provision that on merely on apprehension, one can be sent back to he can be deported.
Your Lordship, that is right, but at the same time, they cannot be denied the right to a fair trial. They weren't even heard and they were deported. And the investigation was done by the Delican police itself, which falls under the jurisdiction of the central government. So there might be a possibility that the central government, to overshadow, to transfer their liability on someone else, they put this case forward and deported those two individuals and blamed the reason for the riots on
But
them.
even if we will allow your petition with regard to get the visa, as and when you will land in Indica, you will be apprehended, you will be sent behind the bars. Then also you will not be in a position to complete your studies.
Your Lordship, that is why we have come to this court for getting a fair trial, so that one can decide that, so that both sides are heard and then a decision can be taken.
That is true, but before fair trial also, they can apprehend you.
Your Lordship, at least after the fair trial, we can come to the solid conclusion that after the fair trial, at least they can have a chance to pursue their education. If they are deported without even being heard, they won't even have a chance. They won't even have a chance to continue their education in Delica. So it's better to have a trial and then decide, other than not to have a trial and then just deport them back to their country.
Where the trial is yet to commence, we are told. Trial is yet to commence. As and when it will commence, they will call you, they will summon you.
Your Lordship, but they shall be given this opportunity to come before the court. That's what all we are asking for, is that for them to stay in Indica till the time the trial has not been completed, so that they can argue and prove their innocence.
So you will be permitted. That is what I am saying. The courts are going to follow the principles of natural justice.
Your Lordship, that is what we are
So then when the trial will commence, they'll consider your case.
Your Lordship, that is what our prayer is, for them to have a chance to present themselves before the court. That's all our prayers. The Council seeks permission to move to the prayer.
Yes.
We have gone through the prayers.
Lordship, correct. The Council now rests this case. Thank you.
Yes. for the respondents.
The council would like to address the as lordships.
Yes.
Your lordship, warm greetings, your lordships. The council is appearing in this honorable Supreme Court of Indica on behalf of the respondent. If the lordships are well versed with the facts of the case, then the council would seeks permission to move to the issues. Uh, your lordship, there are three issues in
Yes, yes.
totality. Your lordship, there are three issues in totality. Two issues will be dealt by the present council, and the last issue will be dealt by my co-counsel.
Yes,
Your
please.
lordship, if you permit, the council would like to move to argument advance.
Yes.
Okay, so uh, first, the council would like to mention the issues. Uh, the first issue is whether the government of Delhi be held liable for failing to curb the increasing pollution in the UT and fail to provide the residents of Delhi with clean and healthy environment. The second issue is where the Vinupal University get the losses for rapid decline in the admission of the foreign students because of the increase in pollution level of the UT of Delhi. And the third issue is whether Mr. Vyat Maddox be permitted to stay in Indica for continuing his education from the Vinupal University, and Mr. Maddox Vance permitted to return to India for continuing his education. Now the council would like to ask for permission to move to the argument advance.
Yes.
So the first issue is whether the government of Delhi be held liable for failing to curb the increasing pollution in the UT and failed to UT of Delhi and failed to provide the residents of Delhi with clean and healthy environment. The council humbly submits that in establishing any industry in any state, some level of pollution would be definitely there, but we are saying that there must be a balance between individuals' fundamental right and development, and the state is fully aware of the ongoing situation. There was a case, a similar opinion was given by the Apex Court in SR Oil Limited versus Halar Utkarsh Samiti. A two-judge bench of this court referred to the Stockholm Declaration while elucidating on the principle of sustainable development. It noted that while socio-economic needs could be fulfilled through development, environmental concerns will always remain. However, these concerns should not be seen as a deadlock between development and the environment, but as an opportunity to harmonize both through the principle of sustainable development. Speaking through Justice Rumapal, the court observed uh, that the aim is to balance economic and social needs on one hand with environmental consideration on the other. But in a sense, all development is an environmental threat. Indeed, the very existence of humanity and the rapid increase in the population together with consequential demands to sustain the population has resulted in the concreting of open lands, cutting down of forests, the filling up of lakes and pollution of water resources and the very air which we breathe. However, there need not necessarily be a deadlock between development on the one hand and environment on the other. The objective of all laws on environment should be to create harmony between the two, since neither one can be sacrificed at the altar of the other. Furthermore, Justice Babu also noted that while the right to a clean environment is guaranteed as an intrinsic part of the fundamental right to life and personal liberty, the right to development can also be declared as a component of Article 21. The right to development cannot be treated, Your Lordships, as a mere right to economic betterment, or cannot be limited to a misnomer to simple construction activities. The right to development encompasses much more than economic well-being and includes within its definition the guarantee of fundamental human rights. The development is not related only to the growth of GNP. In the classical work, Nobel Prize winner Amartya Sen pointed out, the issue of development cannot be separated from the conceptual framework of human right. This idea is also part of UN Declaration on the Right to Development. The right to development includes the whole spectrum of civil, cultural, economic, political, and social processes for improvement of well-being of the people and realization of their it is an integral part of human rights. Of course, construction of a dam or mega project is definitely an attempt to achieve the goal of wholesome development. Such works could well be treated as an integral component for development. The Council humbly submits that the state is taking all the possible measures to curb the pollution, and some of the preventive measures are as follows. So I'll mention some of the preventive measures, Your Lordship, that the state has taken. State has imposed challans and imposition of fine on vehicles to control air pollution in Delhi. State Pollution Control Board has devised a comprehensive plan for and prevention and control of air pollution and to secure the execution thereof. The state pollution has collaborated with Central Pollution Control Board in programs which relates to prevention control uh, of air pollution, and inspections are being done in air pollution control areas, assessing the quality of air, and appropriate steps are being taken for prevention and control of air pollution in such areas. Your
If the
Lordship,
steps are being taken, then why Delhi's situation has worsened so much?
Your Lordship, please repeat your question again. Your Lordship, please repeat your
If
question.
you are taking regular checkups, then why the pollution in Delhi has gone down so drastically?
Your Lordship, the pollution has grown drastically increased because of the protesters. The protesters burned the vehicles, and because of the riots, the many of the vehicles were burned down. And it is written in the fact. It is
So you want to
explicitly
say that the
mentioned.
riots are the continuous process in
Uh,
Delhi?
your Lordship, this is a recent phenomenon, and we know that because of developmental activities, it is also the pollution is also increasing. But in
Right.
the
So the point is, if it is recent phenomenon of riots, but there is a pollution present, worst situation prior there too. There are many
your
persons who have died because
uh,
of pollution.
I understand your point, Your Lordship. Your Lordship, the pollution is increasing because of developmental activities, but the pollution that has been drastically improved. The primary reason for that is because of riot. We want to submit that because whatever pollution has been increasing because of developmental activities, we are trying to control it. We are trying to look at the locations of industries. We are trying to fix the locations. We are trying to look at the emissions, and we are trying to control the amount of pollutants that they are emitting. We are trying to fix that, Your Lordship.
It is a
But
failure on your part so far. You have failed miserably. Since long it is going on and you are not curbing it. It is
at
Your
least
Lordship,
thankful. We at least we are thankful so far as the Hare Paryavaran, and they have filed this petition so that we can at least come to know that what is situation prevailing in Delhi.
Your Lordship, the state is taking necessary measures. We are collaborating with Central Pollution Control Board, and the Delhi State Pollution Control Board is collaborating with Central Pollution Control Board and looking at what measures we can take, and looking at what reasonable what how we can control things in a more better way. But till now we have fixed the locations. We have changed the locations of industries. Now the industries are not in the industries have been the industries are not located. We have just after knowing that the pollution is increasing, we have looked at the industries, and industries are now in the area where the population is less populated, where it is less populated areas. So we are taking necessary measures that the state can take, Your Lordship, and we think
you are
in the
only
coming.
discussing on papers with Central Pollution Control Board, State Pollution Control Board, here, there. Everything is on paper. Nothing is in action.
Your Lordship, we are trying to curb it, Your Lordship. We are taking necessary measures. It will be evident in the upcoming months, or in the few months to come. Right now, because we have so much of because the state is having so much of money is being granted to the state. The FDI is happening in the state. So because of developmental activities, things are
Developmental activity
aggravating.
should not be at the cost of life.
Yes, Your Lordship, indeed, Your Lordship. The developmental activity should not be at the cost of life, but we are trying to balance it, Your Lordship. We are trying to create a harmony between ecology and the development, Your Lordship.
Don't you impose restrictions at the time while granting permissions? And therefore, don't keep a check on it seems.
Your Lordship, if industries are found to be emitting more pollution, we will keep check on that. We are keeping check on that, and till now we have found that they are abiding by the rules and guidelines of the State Pollution Control Board.
for deporting the students, you are very fast. And so far as question of curbing the pollution is concerned, you are still thinking and you are still in the process of taking steps. Those students are deported.
Your lordships,
Before
we
given opportunity to the students.
Your Lordship, it was an instant reaction from the side of the state. Want them to, the state will reissue the visa and want them to come back and go through the trial. But we will not allow them to study because it will, if we will allow them
Any
to study.
person, any person, if he speaks against the state, you want to deport him, but you don't want to take action when there are so many people who are dying.
Your Lordship, Your Lordship, we are giving we are giving mass air marks to people. We are giving 2 air marks to each family, and Your Lordship, we are trying to control the pollution emitted by vehicles and industries too. Your Lordships, and about the deportation of Metox vans and Wyatt Maddox, the council thinks that uh, it was an instant reaction from the side of the state, and we are ready to issue them visa and to allow them to come to the country, and
So
we will
far
go
as
for
third
trial.
petition is concerned, you are conceding that it may be allowed.
Can you repeat your question, Your Lordship?
A third petition filed by the Maddox, you are conceding that that petition may be allowed.
But that petition would be only to only for trial. That petition would we will not allow them to study because that would pollute the mind of the fellow students, Your Lordship.
How come you are say without even putting them to trial that they had polluted or they are involved in this activity, therefore they are going to pollute the mind of other students?
Your Lordship, they were passively involved through WhatsApp chats and Snapchat chats, and it
That
is
that
very
is that is merely a investigation done by your agency, a report of an investigation done by your agency. Except that they are not even been heard, they have not even been granted opportunity of hearing. On that basis, you are saying that we have deported them. Now you are accepting that it was merely an instant reaction, and therefore we are reissuing them a visa. We are calling them back, but we don't allow them to study.
Your Lordship, at the first instance, the state thought that it would be feasible. It would be great. It would be nice if we deport them back to their country because we would have some time to think about what we could do later on. So
You are starting thinking about the same after a loss of 3,000 lives.
Your Lordship, it's not just because of the pollution emitted by the industries that the life has been lost. There are different factors too, and the factors are like the residents of the UT of Delika. They need to be more aware about their duties towards the state and the
State will
even
not do anything. State is not responsible for anything. But either industries are responsible, either citizens are responsible. But state is very clean. State will not take any action in curbing the pollution. That is what your submission is.
uh, your lordship, we are contending that some amount of pollution is being emitted by the industries and factories. We are looking after it, and we are trying to regulate each and every industry that we have in the densely populated area. We are even locating them in areas where people are very less, where it is less populated areas. So we are
But you
doing
will
we are
permit
taking
emissions to go out in the environment. Only by
pardon, your lordship.
relocating them, you are relocating the industries where the population is less. But you will not curb the pollution. You will permit emissions to go out in the environment freely. By merely
No, your lordship.
relocating, how would it help you?
Your lordship, we are looking at the industries and looking at how much emissions they are emitting, and by looking at the emissions they are emitting, we are trying to regulate. Till now, we have regulated most of the industries, and still there are some industries which are emitting pollution. We are looking after that, and in very short period of time, we will keep check on all the industries in the state, your lordship.
So you mean to say That you mean to say that if the pollution occurs, then the responsibility is of the citizen. If the riots occurs, then also the responsibility of the citizen occurs. So every time the duty of the citizen is there. But what about the fundamental rights of the citizen? You have
Pardon your
miserably
lordship.
failed. You have miserably failed to curbing the pollution. You have miserably failed to maintain law and order situation. What do you want to say on that?
Your
Why we
lordships,
should not allow the petition of compensation? The person who have lost their lives.
your lordships, the council thinks that it was not the state has tried to regulate all the laws of the land, but because the state couldn't do much about the riots which happened. We
But who will
our
do?
our mes-
Who will
your
do?
lordships, your lordship, it is your lordship, the state tried and took all the necessary measures, but our resources are limited, so we couldn't do much about. We didn't know that the students of a university is provocating the violence. We got to know about this later on, so we now that we know about it, we'll take strict action on these students, your lordship. Your lordship, I would like my co-counsel to answer two questions.
Your Lordships, am I audible?
Yes.
So, Your Lordships, may I proceed with the issue 3?
Yes. Yes, you may be good.
Yes. Okay, Your Lordships, issue 3 is whether Mr. Wyatt Maddox be permitted to stay in Delica and Mr. Maddox Vance be permitted to come back to Indica for continuing his education. So it is humbly submitted before the Honorable Court that Mr. Wyatt Maddox should not be permitted to continue his education and Vinupal University in India, as well as Mr. Metoxen should not be permitted to return to India for continuing his education from the Vinupal University. The council would humbly like to bring into notice of this court that both the persons have been involved in the anti-national activities by inciting the mob through various social media platforms such as Snapchat and WhatsApp, and even the police report has a clear evidence about the same. Further, no person shall have have any claim to his fundamental right of speech and expression under Article 19 if found guilty of any anti-national activities, and these were foreign nationals, so they anyway had no fundamental right under Article 19 of the Constitution. Furthermore, the council would like to submit that both the students were provoking and inciting.
Is Article 21 available to foreign nationals?
Yes, your lordships.
Then right to education is also available to them. They want to pursue studies here.
Yes, your lordships. But their right to education is limited, right? They cannot come on and seek the right to education and then do activities that interfere with the peace of the nation.
Declaring their own viewpoint, would it amount to anything against the nation or any activity which is not in the interest of nation?
Yes, sir, but there has been police report which stated that there was a passive support in the activity. So it was not just declaring a viewpoint. There was
Have
a
you
support,
permitted
right?
them to give their defense at any stage?
No, we haven't, because as my co-counsel said that it was in the instant case that we thought fit to deport them back, but we are gladly willing to get them back to India and have a fair chance of trial on them. But if they are found
It seems
guilty,
that
not
when
be
you
able
have
to continue their education within the
it seems
university.
that when you have deported them, thereafter to look say of this that those criminal intent is an afterthought, and that because you are now is putting this case of a criminal intent.
No, it was not actually an afterthought, but we lacked some evidence to prove the same. That only we had a police report with passive support, which stated passive support. So
If
we
you
lacked some
you were
evidence,
lacking some evidence, then how can you deport them?
sir. But there was WhatsApp chats which clearly stated that they were supporting. Now, in what way they were supporting, we can have a fair trial and we can look for the same. And if they are found guilty, then we will deport them back, no, actually charge them under the Indian laws, and they would not be able to continue their education any further.
Everyone.
If they were found totally clean,
Yes,
then
your lord. So if they are found totally clean, then we are gladly accepting the fact that we were wrong, and
it would be an irreversible situation.
uh, that
Crucial year of their life will be wasted.
it's not that 1 year is to be taken for the pleadings to
So
continue.
you are ready to put them for trial. You are ready to accept them. You are ready to reissue the visa. Now, in that situation, not allowing them to study is nothing but an waste of arbitrary action on the part of the
No,
state.
no, sir. We are not saying that we are not
At the end of the trial,
allowing them to study. We are saying till the till the time the trial has to took place, they can study. But if they are found guilty, then they would not be able to study.
if that is the case, then at the first instance, cancellation of their visa and deporting them, that action itself is an arbitrary action.
Uh, that we accept. That we accept on our own
Therefore,
part.
third
That
petition, according to your, as you both of you have considered the fact, therefore we are allowing the third petition. So third petition is allowed. You are supposed to reissue visa to them. You are supposed to allow them to study here in
yes,
the
sir.
university.
And thereafter you have to put them a trial, and only after the trial there has to be an action.
Yes, sir. That
And,
is
and
totally
other side would not mind in facing the trial.
yes, sir. That is totally acceptable.
Petitioners' lawyers would not mind in facing the trial.
Yes, sir. So, would I continue towards the prayer?
Yes.
Yeah. Wherefore, in the lights of facts presented, issues raised, authorities cited, and arguments advanced, it is most humbly prayed before this honorable court that it may please to dismiss the petition, as there is no ground for establishing the guilt of the government and is merely a public interest litigation, to dismiss the appeal of the Vinupal University for compensation, and to dismiss the appeal of Mr. Maddox at White Maddox for returning to India, and pass any order or decree or relief which it may deems fit in the best interests of justice, fairness, and equality. Thank you, Your Lordships.
Rejoinder if Team 6 want to give. So far as your third petition is allowed, so there is no requirement of giving any rejoinder on that aspect. Your two petitions, they are opposing. What do you want to say?
Your Lordship, as the petitioner specified
To
that
give
they
an answer to,
Just a minute.
just a minute. Before that, you have to give an answer to my brother, which they have said to the other side that you are ready to face the trial. Only giving an assurance that you are ready to face a trial, then and then your petition will be allowed. What do you want to say for that? That you make your stand clear.
Your Lordship, we are ready to face the trial since they were given no chance to be heard before the courts of India, and their right has been violated. So, yes, please allow the third petition. Your Lordship, as the petitioners mentioned, that the government has taken several steps like introduction of challans and comprehensive action plan and certain programs in collaboration with the Union of India, Indica. Thus, we would like to contend that though uh, they have they have allowed some programs in paper, but these programs have not been efficaciously uh, efficaciously implemented, and thus there are no results as visible in this part. Further, they contended that it is the duty of the citizens to protect their environment. Though we agreed to their contention to a certain extent, but that doesn't means that the government would shed its liability to responsibility to protect the environment. Thus, these are the contentions we posed towards the petitioners.
No, that is true. So far as pollution aspect is concerned, it is true that it is a pollution, no difficulty. And the government is also ready to take necessary steps for curbing the pollution. So the first petition, it will be taken care of. The third is already allowed. Now the second, the question with regard to that compensation and all. There, our view is that you are not entitled for compensation. If you want to get compensation, then also the petition for disputed question of facts is not maintainable. The second point, that it has to be first calculated that what is the compensation is required. It is not mentioned in your memorial or in prayer that what is the compensation is required. So there we are rejecting. What do you want to say? However,
Your law.
however, we'll give you the liberty to file appropriate suit before the appropriate authority. What do you want to say?
Your Lordship, the council feels that the university's right was violated and they should be compensated, which according to what the court deems fit. Secondly,
Which right is violated?
uh, your Lordship, the right to trade and profession, their right to
No,
livelihood,
no,
was
no.
violated.
Nobody has passed any order. Nobody has restrained you from doing your profession.
Your Lordship, but that right was harmed in a way that the students were not coming to their college to join to study.
That
Therefore,
is very disputed question of fact. You cannot say directly that only because of the pollution you are not getting the students. It there are
Can be
number of
other way
reasons,
around.
reasons and
Can be other way
reasons.
around.
Your Lordship, in
For
the
that,
memo,
for that the compensation is not maintainable at all.
Your Lordship, then if the court, if you think that you can, the Lordship can let us appeal in another appropriate court, then the councils would like to go ahead with that.
Your Lordship, it is a
So
circuit.
you are saying that you will withdraw this and file appropriate proceeding before the appropriate authority. That is what you want to say.
You were saying something about the memorial. What you were saying?
Your
Yeah.
Lordship, if it is explicitly mentioned in the paragraph number 7 of the Moot proposition that due to the degradation of environment and due to the increasing levels of pollution, the students are not taking admissions in the Vinupal University, and that has certainly caused damage to the university and in exercise of its rights. And that's the reason we are demanding for the compensation, since they are not able to practice their profession in the entirety they could if there were not if there was not any environmental degradation on the government's part.
So you mean to say that as it is mentioned in the memorial, it is not a disputed question of fact, and because
Indeed,
of
Your Lordship.
reason you are not.
It is.
getting-
Indeed,
It
Your
is
Lordship.
the fact which is mentioned that because of this reason you have filed a petition, right? But the other side has to say something else. They say that no, you are not entitled to compensation.
And anything which is not directly connected, it cannot be considered by this court, at least at this stage.
Pardon, Your Lordship.
Without, see, if you want to say something, if you want to libel someone, then there has to be a trial, there has to be a leading of evidence, and then you can say that this person has injured me in this much quantum, and then therefore the compensation.
Your Lordship,
The state, you have filed this petition against the state. The state has not done anything.
Your Lordship, the state has not fulfilled its obligation. It was supposed to. The state has failed to do its duties as mentioned in the constitution, and that's where the state is lacking on its part, and that's why we have filed a petition against them, since because of their non-compliance with their duties and because of their omission of their duties, the petitioners are severely damaged, and that's the reason we have approached this court for compensation that we deserve.
And
Lordship, you're not audible, I guess.
In your last prayer, you have mentioned just to compensate by the state. Then you have not mentioned what kind of specific compensation you want to get from the state and industries.
In,
You should have specific mention in your prayer. Or what compensation, like monetary compensation you want to get from the state, or either what kind of compensation you want to get from the state?
Uh, it is the monetary compensation for the loss of
Then you will have to quantify the compensation.
Yes.
as the court may deem fit as they calculate.
You are throwing burden on the court to calculate the compensation. Therefore, we are saying that it is
No,
better you go to tribunal.
Yes.
Section 14 empowers the tribunal to do whatever you are saying. All civil rights can be considered by the tribunal.
Or any other court which you.
Your Lordship, but as already answered, the matters were intermingled, and we could. It was very cumbersome for us.
No, no, now out of three, two are already over.
Yes.
Now only one matter remains. One is allowed, one we are ready to pass an order. The question with regard to the compensation remains, which you have not even calculated, which you want us to calculate first.
No, Your Lordship, we don't want you to calculate, but we plead the court to appoint an expert committee in that regard, so that they would evaluate the losses and they would evaluate the specified amount of compensation by a fair investigation in that matter.
No,
So
but
prior to approaching the court, you have not done anything. You have not even quantified your losses because there are less admissions, less application to your university. You had straightway approached to the Supreme Court without even quantifying the number of students which have not taken admission or losses suffered to your university.
Your Lordship, that is very subjective because the investigation, in its true sense, have not been carried out yet.
That is
By
what we are saying, that it is very subjective matter, and that subjective matter cannot be adjudicated in a Supreme Court. For that, you will have to lead the evidence before the appropriate tribunal or appropriate civil court, and after leading evidence, court will decide the amount of compensation. We will consider about your alternative prayer about appointing some expert committee and quantify the damage. Anything else you want to submit?
no further submissions as of now, Your Lordship.
Any sir rejoinder from team 1?
Your Lordship, the counsel for the respondent would like to say few things, submit few things on compensation. Your Lordship, the monetary compensation should not be awarded to the university, as there is no clear-cut evidence to prove that the decline in the admission of foreign nationals in the Vinupal University is direct result of environmental degradation and not because of quality of education being provided to the students of the university. There could be a case of genuine dissatisfaction among the students regarding the teaching methods or the overall curriculum of the university. Further, the council would argue that the other reasons for the same could be that the university premises might not have been safe for them, as them being foreigners were most prone to ragging, would have been most prone to ragging and racial discrimination in case university fails to protect them from the mistreatment by other students of their peer group. Secondly, they might have been unsatisfied by exorbitant fee structure of the university.
No, but
The
the
council
factual situation suggests that because of this rise in pollution, students have stopped taking admissions. The submissions which you are making about ragging and increasing fees and quality of studies, etc., are merely on the basis of assumptions and presumptions. Do you have anything to suggest that these are the situations prevailing in the university?
uh, your lordship, the council submits that there is no rule or law which says that state will compensate to the university for decline in admission of foreign students, whatever the reason may be. Uh, moreover, here in this very case, the council wants to ask that on what basis the government of Delhi should compensate the university if there is no fault on the part of the government. As stated in issue number 1, it says that the government of Delhi has been taking all the regulatory and preventive measures to curb and control the pollution, to control the pollution. within the UT of Delika, and there is no fault on the government side. The council also wants to humbly submit that and highlight the issue that the university might have a poor academic curriculum. Your Lordship, the 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 contention for compensation is from the side of the petitioner, and we do not accept that contention. Your Lordship,
The Venerable University is a prestigious university, and students from all over the globe is coming. So it's a face of Elika to the globe. So a state should take care of such university so that the face of the Elika is in a good shape.
Your Lordship, many a times it happens that the university degrades its quality. The quality of university degrades, and university doesn't stand on their previous records. So there could be different reasons for that. So without any substantial evidence, if the petitioner wants to say that it's solely because of pollution, we do not accept that stand, Your Lordship.
Okay. Anything else? What do you want to say about their alternative submission of appointment of any experts committee to quantify the losses? Are you opposing to that prayer as well? Expert committee can be of your choice. State can select the experts and can form a committee so as to quantify the losses. What do you want to say about it?
Your Lordship, if we need, if the committee is fair and they want to quantify how many losses, and it is, if it is only because of solely because of the pollution, then we would accept that. If it is solely because of pollution,
So you
uh,
want to say that committee should not be formed only for the purpose of quantifying the losses, but also for the purpose of deciding the reason for the damages to the university.
indeed, Your Lordship, the committee should be formed looking at all the grounds, Your Lordship.
So we can appoint an experts committee with the assistance of the union. You can suggest the name of the committee members and we can appoint that committee.
Indeed, Your Lordship, we can the council can discuss about that, Your Lordship.
So is it only for university, restricted for university, or we can also direct the committee to look into the aspect of the citizen at large, those who are affected because of.
Could you repeat the question, Your Lordship?
Do you want us it is only for with respect to the university the committee will be formed, or it will be with respect to
For
all the
industries
citizens, or for everybody, and the liability can be fixed by the committee even for the industries.
Your Lordship, if a bona fide committee has to be formed, if the Honorable Supreme Court can form a bona fide committee to look at all these issues together, then the counsel for the respondent has no problem with that.
Very good.
Very good.
Everyone has to accept the committee appointed by the Supreme Court will be bona fide and will act without any prejudice. That you will have to accept it. You cannot question the appointment of the committee by the Supreme Court. You cannot doubt the committee if it is appointed by the Supreme Court.
When
Apologies.
there is a fair proposal from the bench that you can select your own panel for the committee, your own committee.
Apologies, Your Lordship, for the use of word.
Now we guess that all of you have raised your submissions.
Yes, Your Lordship.
We'll decide and we'll let.
Thank you, Your Lordship. Thank you.
Thank you so much, sir, jury team. If the jury team likes to give some suggestion or some sort of expertise knowledge to the participants about their performance or further improvement, they can share that if any jury members wish to.
No, I would only like to suggest all the four mooters and researchers the jury may put any query. Jury may be sometimes jury may be very aggressive, but you should not lose your line of arguments. You should stick to your line of arguments with humble answer to the jury. So jury may sometimes ask questions at initial stage, in the midst of the argument, or at the end of the argument, but that should not uh, be construed as that our entire we were been not given an opportunity to put forward our case. So you had to concentrate to your line of arguments, and thereafter, after satisfying the court's query, you can again start from where you have ended. So you all should keep that in mind in future as well.
The queries are always put to find a way out. If there is a dispute which has come up before the court, then the court would want to find a way out. So it may not so happen that the queries be taken as if the court is against you, right? It's always that they want to find some way out for you.
And in future also, see, on one day you will hold a brief of petitioner, you will hold a brief of respondent on another day. It may happen also that the court may ask one question to the other side and three questions asked to you. It does not mean that court is against you. Sometimes it is more suitable for the court to understand that if I want to give a relief to this person, let us clear all the doubts in my mind. So it may also happen that sometimes more question comes will also lead to a situation which will go in your favor. So the number of query is not relevant.
All four of you are overall very good. All of you have done very good research. The application of law about facts, everything was very up to the mark. And you four had increased our burden to decide what to do.
Best of luck for your life to all.
Best of luck for future.
Thank you so much.
Thank you, sir.
Thank you, Your Lordship.
Thank you.
Thank you so much, jury. We have our principal, Dr. Rekha Kumari Singh, as well on the dais. We would like to request the jury members and all the participants to turn on their camera so that we can capture this final round moment. I would request all the jury members, all the participants to please turn on their cameras so that we can capture this moment. As well as the court assistants, the students, please.
Thank you.
Thank you. Thank you so much. Now I would request Mr. Ranveer Singh Maheda, sir, to give vote of thanks. Over to you, sir.
Good afternoon, everyone. Myself, Ranveer Singh Maheda from Anand Law College. On behalf of Anand Law College and Anand College of Legal Studies, I would like to thank Ms. Tuti Kapadia, President of Juvenile Justice Board, Mr. Harshad Ray Dave, sir, Mr. Hardik Dave, sir, Mr. G.Y. Pathan, sir, Mr. Japan Dave, sir, Mr. Rahul Dave, sir, and Mr. Pawan Bharat, sir, for esteemed judging the final round of 5th National Moot Court Competition 2022. I would like to thank all the participants of the National Moot Court Competition 2022 for successfully participating in the competition. We will declare the result of final round in the valedictory round, which will start from 4 p.m. today. It is my humble request to participants kindly remain in the session till our judges are in the session. Thank you all.
We may end this. Thank
Thank you.
you. Thank you.
All the best to all participants.
Thank you, sir.
Thank you, sir.
We will be sharing the validatory round joining link to you in your mail, to your mail, and there we will be declaring which round will be the final round. Okay, see you at 4 p.m. today. Best of luck.